surround Seattle and includes Seattle, Washington. It's also my pleasure to be currently serving on the ABA Commission on Immigration. We have a number of ABA Commission members here, and a couple more will be trickling down. We just finished the business meeting upstairs. Thank you for attending our program today, which is the title, Controversy Delays Progress, Prospects for Immigration Initiatives in the Next Administration. Despite broad public support for comprehensive immigration reform and near universal agreement that the current immigration system needs significant improvement, Congress has taken little action, and the current administration's efforts have been limited. It is true, of course, that certain immigration issues are extremely controversial. Many people have very strongly held opinions and beliefs. But partisan warfare and gridlock make it seem that as if nothing is happening, even on common sense administrative measures which enjoy broad support. In fact, all one has to do to stop all discussion is simply to say immigration. How often have you seen that? We try to have a common sense discussion, people try to find common ground, and somebody raises a particular visa or just says the mere topic, immigration, and nothing occurs. We have a new administration coming in. So what are the prospects for improvement under a new administration? Of course, we don't know who the next president is going to be. Of course, there may be differences in terms of approach, policies, and procedures. But what are the prospects for improvement under a new presidential administration? Given the recent decision by the United States Supreme Court in Texas versus the United States, is executive action still a viable option for the new president? What are the prospects and strategies for improvement for attorneys and advocates who must navigate their practice in the next few years? Many CLE panels are retrospective in terms of review of the case law, review of precedent, and more traditional kinds of analysis. But we're going to try to do something a little bit different. And we're going to do a little bit of the traditional analysis, particularly what we do with the effects of Texas versus the United States. But we're going to try to look forward today. As busy practitioners and judges, we're often so involved in our cases, in our day-to-day cases, that we don't have a chance to look up and ask, where are we going? So, where are we going in the next few years? To help us, we have an extremely distinguished panel. And if I were here, if we were to go through their complete bios, we'd be here for a long time. So we're going to do a truncated bio. And they are indeed friends and colleagues of many of the people sitting in this room. First we have, from Maldiv, Thomas Sands. In 2009, Mr. Sands returned to Maldiv as President and General Counsel. Previously, as counsel to Los Angeles Mayor Antonio Villagrocia, Mr. Sands served on a 4-person executive team to the mayor, where he provided legal and policy advice on major initiatives. During this 4-year period, he championed numerous initiatives. He also, in his current role, he's played a key role in Texas versus the United States litigation, which we'll talk about a little bit further in a few minutes, and also serves on the ABA Commission on Immigration. Next, we have Professor Denise Gilman. Professor Gilman teaches and directs the Immigration Clinic at the University of Texas Law School at Austin, since having joined that clinical faculty in the fall of 2007. Professor Gilman has written and practiced extensively in international human rights and immigrants' rights fields. From 2002 to 2005, Professor Gilman was the director of the Immigrant and Refugee Rights Project at the Washington Lawyers Committee for Civil Rights and Urban Affairs. At the Lawyers Committee, Professor Gilman coordinated the representation of political asylum applicants by pro attorneys and engaged in advocacy on issues of significance to newcomer community. Next, we have Jennifer Shee. She is a partner with the San Francisco law firm of Simmons and Hunter, one of the oldest law firms on the West Coast of the United States, practicing exclusively immigration and nationality law. She has more than 18 years of experience in representing and advising employers hiring and retaining foreign talent on a temporary or permanent basis. Her clients include information technology services companies that use a global delivery model, engineering and construction companies, and international human rights and public benefits corporation and nonprofits. She also represents healthcare professionals, business owners seeking E2 classification, and self-petitioning professors, research scientists, and this is my favorite part of it, you also represent creatives. So with this distinguished panel, we're going to talk a little bit about where are we going. So we'll turn over the floor first to Science.
Thank you, Judge Lum, and thank you to the ABA and the Commission on Immigration for convening this very timely discussion. It's good to have it with a group of good friends and folks informed on the issues. Of course, you all know that some 6 weeks ago, the United States Supreme Court issued its non-decision, indicating that it was deadlocked 4-4 on an 8-justice court in the appeal from the preliminary injunction, nationwide preliminary injunction issued by Judge Andrew Hanen to block the initiatives first announced by President Obama in late 2014 to create deferred action for parents of Americans and to expand the pre-existing deferred action for childhood arrivals. So it was a disappointing decision, somewhat unexpected given how long the justices had waited after the oral argument to indicate that they were deadlocked. Certainly it was disappointing to the many, many people, 1,000 or more, who amassed outside of the Supreme Court on April 18th, the date of the oral argument, hoping to influence the justices to make a decision that would, first of all, provide relief from the daily fear of deportation faced by millions across the country, including the heads of families that include United States citizens, of course, but also would have ensured that immigration enforcement is more uniform and non-arbitrary nationwide, and that may give a sense of where I think we have to go with respect to the set of issues raised in United States versus Texas. But first, technically, where is the case today? The United States filed a petition for rehearing with the Supreme Court on July 18th when it was due. It is a long-shot possibility that the 8 justices, or at least 5 of them, will decide to hold the case over and rehear the preliminary injunction appeal with a full complement of 9 justices, likely sometime in 2017. The latest is that that petition was distributed to the Justices' Chambers apparently yesterday, so they are in the beginning phases of determining whether there are 5 justices to retain the case and hold it over or not. In the meantime, Judge Hanen had scheduled for August 22nd, as you may recall, a status conference to consider again enforcing his previously issued order of sanctions on government attorneys for their alleged misconduct in front of him and during the course of his consideration of the preliminary injunction. His sanctions order included what I think all would agree are sanctions on attorneys, disqualifying some government attorneys from appearing before him, requiring others to go through training on ethics and the like, but also included a very ominous order that information be turned over by the Department of Homeland Security regarding thousands and thousands of recipients of deferred action for childhood arrivals who had received 3-year grants or renewals of deferred action and who reside in one of the 26 plaintiff states. He has now, as of today, up to the minute updates, postponed that August 22nd status conference to August 31st, and still the prospect at the end of this month that he could renew his order that that information be turned over, first to him, and then on an appropriate showing, as he said, he would turn that information, identifying information, address information, and the like, over to the plaintiff states if they showed him that they were harmed somehow by not having that information. obviously a very serious concern about the privacy rights and indeed the continued safety of those DACA recipients of 3-year grants or renewals, and an issue that will not end certainly in Judge Hainan's court. There is already a pending Fifth Circuit appeal filed by the interveners whom MALDEF represents that is currently stayed as a result of Judge Hainan's decision in early June to postpone until August 22nd, now the 31st, his implementation of his order from May requiring that that information be turned over. Further down the line, in terms of the case, a lot depends, obviously, as so much does these days, on who is elected president in November. Obviously, if one candidate who's already stated his strong opposition to the initiatives announced by President Obama is elected, the case would be mooted on his first day when presumably he would withdraw the directive creating deferred action for parents of Americans and expanding deferred action for childhood arrivals. If Hillary Clinton is elected president, then I think the question is whether she and her advisors decide it is better to move the case by withdrawing the specific initiatives put forward by President Obama and substituting her own presumed enforcement prosecutorial discretion initiatives and face the prospect of a new lawsuit undoubtedly being filed against those, with the possibility that it not be from Judge Hainan, with the possibility that it would move more quickly toward a resolution that would permit implementing those initiatives. Or she and her advisors would decide it is better to move forward with the case as is, particularly perhaps if a petition for rehearing has been granted, or even if it appears that Judge Hainan will move toward final judgment in this case more quickly than any new case could move toward resolution, or before they could defeat an attempt at a preliminary injunction in any new litigation. But obviously that's just the parameters of what would happen in the case itself. The bigger concern is what would happen more broadly with respect to immigration reform and the specific set of issues that were addressed by the President's initiatives that he announced first in 2012 with DACA and then the expansion and creation of DAPA in 2014. I think here it's important to recognize that there are a number of forces behind his decision to make those announcements. First, obviously, was the House of Representatives' refusal ultimately to take up any immigration reform legislation after the United States Senate passed its version of comprehensive reform in 2013. As I'm sure many of you are aware, there were movements on the part of House leadership toward a set of bills, not a single bill, but a set of bills dealing with discrete issues in the realm of immigration reform, but all of that conversation came to a screeching halt when Eric Cantor was defeated in the primary in 2014, and since then there has been absolute silence and complete stasis with respect to considering immigration reform legislation. Perhaps more important than the outcome of the presidential election and with respect to the prospect of legislative reform is, of course, what happens with respect to the U.S. Senate and the U.S. House. And it's not as simple, of course, as saying a shift in majority is what is necessary. It's really a matter of the current majority feeling free, if it remains in the majority, as it did prior to Cantor's defeat, to move forward with discussions, debate, and possible enactment of legislative reform. So there's really no way of knowing, unless someone out here 90 days before the election knows what the outcome will be with respect to the House and the Senate. But politics aside, and this is where the controversy that Judge Lum talked about really has gotten in the way of so much potential progress, there is the practicalities behind the President's announcement of these initiatives. I think there's no question but that the Obama administration's experience with trying to follow nationwide policies of prosecutorial discretion that reflected the views of the administration up until 2012 and the initial announcement of DACA, and continuing thereafter with respect to the folks who would be potentially eligible for DAPA, was an inability to ensure nationwide uniform application of prosecutorial discretion criteria articulated from the top. And that is a reality. Any better indication of that, and you need go no further than recognizing that the leader of the union representing ICE agents filed a challenge to the original DACA that was, perhaps not ironically, but which should be expected. That case was kicked out for lack of standing by those ICE agents and the state of Mississippi, which also joined that litigation. But the filing of the case is a measure of the animosity and opposition of many of the rank-and-file decision makers in ICE and DHS with respect to the announcements from the top. So the conundrum that the president faced was not being able to have policies articulated from the top be followed everywhere in the country. The initial Morton memo, which started out as a directive that was going to be nationwide, morphed into a pilot project in certain jurisdictions, in part because of that demonstrated inability to control the actual application of discretion nationwide by rank-and-file officers. That is the conundrum that any president will face, including a President Donald Trump, who will have to decide how to use enforcement resources that are not remotely adequate, certainly to address all of the undocumented immigrants in the country. So he too, no matter what he may say rhetorically, will have to decide how to target those resources and whom within that population to target first. And I think that there are three ways of addressing this. In some ways, we've seen attempts at two of them, at least within the existing administration. First, and what we know about Donald Trump, perhaps this is what he would try to do, there are command and control steps that could have been taken more aggressively to control the rank and file. Indeed, from the beginning of the administration, one of the things I've said publicly to the White House and otherwise is it's an extreme irony, an unexplained irony, that the federal government through the Department of Justice has demonstrated the ability to change the culture of law enforcement agencies at the local level. I come from Los Angeles. As you heard, I worked for the mayor of Los Angeles. The Department of Justice changed the culture of the Los Angeles Police Department through its intervention and its consent decree. And it did that in a very similar context where rank-and-file police officers didn't feel any obligation to follow the new policies or directives of a police chief because they knew that their careers in the police department would last longer than any police chief and than any mayor. And you therefore have to change that culture that says you can passively or even more actively resist the directives from the top. But the irony is the Department of Justice does that, perhaps not as aggressively or as frequently as many of us would like with respect to local police departments, but the federal government has failed to take the learning from the Department of Justice and apply it to its own sister agency, ICE, in the Department of Homeland Security. But there are certainly command and control steps that could be taken to exercise greater authority over how discretion objectives articulated at the top are implemented nationwide. Those steps were not taken by this administration. Second, of course, you could basically allow your directives to be ignored and have non-uniform arbitrary enforcement. Arguably, I think there are serious legal problems with that course of action. And there are certainly very serious human harms that we have seen inflicted by a failure to see to uniform non-arbitrary enforcement of prosecutorial discretion objectives across the country. And the third step is basically what the administration did, which is to create a process of centralized decision-making with respect to those who are presumptively eligible under the articulated enforcement priorities articulated at the top. So the creation of deferred action for childhood arrivals and the creation of deferred action for parents of new Americans was, politics aside, an effort to administratively ensure uniform and non-arbitrary enforcement nationwide of discretion objectives articulated at the top by ensuring that decisions would be guided by presumptive eligibility and would be made in a more centralized fashion than they are in the ordinary course across the country by ICE and DHS agents and officers. So ultimately, whatever questions, and there are serious ones, that remain from a one-sentence order non-decision by the Supreme Court, this issue has to be solved in 21st century bureaucracy. No matter who the president is, he or she will need to be able to have confidence that their directives will be followed, and will need to find a mechanism to accomplish that. It seems that what President Obama announced is a very effective mechanism of doing it, but the Supreme Court is now in the position, through an unexplained one-sentence non-decision, of basically blessing a preliminary injunction where the standing of the states challenging it is questionable in the extreme, and where the legal issues surrounding the directives were very strongly in favor of the president, who acted consistent with actions of many of his predecessors, including the most cited and most analogous exercise of such discretion through the Family Fairness Program of that great open-bordered liberal President Ronald Reagan. So, my projection is we will not know until November what will happen legislatively. We may not know, of course, until November what will happen administratively, but no matter what happens in November, there will have to be a solution to this issue to permit the president, whoever it may be, to ensure that their objectives and decisions that have to be made, given inadequate resources, about targeting enforcement resources, are followed uniformly and not arbitrarily across the country.
We're going to take questions in just a little bit, but we're going to turn the floor over to Professor Gill.
Thank you very much to the Commission on Immigration and to the organizers for having me speak at this event once again. I feel a little bit like a broken record because I've been speaking for the last couple of years on the current treatment of Central American refugees, asylum seekers in the United States, and I'm going to be continuing forward with that theme today, but I am very grateful for the opportunity to address the topic today because we're now officially at the sort of 2-year mark of the current system in place, which really emphasized detention and deportation of Central American asylum seekers. It really began in the summer of 2014, and so I think it's important to mark that reality and then to think forward from here. You know, if Tom's story was one of sort of partial progress or efforts and then frustrated efforts, the story on Central American refugees, unfortunately, I think is one of significant backsliding and increased harshness towards refugees over the last several years. You know, it was really that 2014 mark when, as I say, the emphasis was placed on detention and deportation. And really that was actually a stark turnabout even within this administration. And so in order to look forward, I do want to bring us back to 2009 first before going forward. And recall that in 2009, the new administration came in and one of the hallmark reforms of the administration in terms of immigration was the idea that we really needed to move to a true civil detention system where detention was needed, acknowledging that detention of immigrants need not be as widespread and certainly need not be and should not be as much of an incarceration model, and that significant reforms and measures should be taken. And in fact, one of the first things that the administration did in terms of its broadly announced detention reforms was to end the practice of detaining families of children and their parents. So that was 2009, and the decision was really made because the family detention model was standing on questionable legal grounds at that point. There had been significant litigation, but it was also really sort of an understanding that detention on this model was inappropriate for the community, for the populace that was being detained, for migrants who were seeking refugee protection, who had sometimes many years in the United States, long-term ties, and who were not serving, of course, in this context, a criminal sentence, but rather were being held for administrative purposes, usually to prevent flight risk or danger to the community, or the rationales normally provided for the detention of immigrants. And so the acknowledgement was that where detention is not absolutely necessary to meet those goals, it should not be used. But then, as I say, in 2014, when the numbers first, notably, the public started to realize that there were many, many unaccompanied children migrating from Central America, and then it soon became more public that there were children coming with their parents who were coming to the southern border seeking protection in the United States. And I do want to put into context that environment of the summer of 2014 and think about the fact that while it is true that there were significantly larger numbers of Central American children and their parents coming to the United States, we were very much at a historic low still in terms of overall unauthorized migration arriving at the southern border. And it's really, the numbers are quite dramatic when you actually look at them, the government statistics. In 2000, we had about 1.5 million unlawful border crossers. In 2014, at the height of this situation, which some called a surge at the time, we were talking about between 300,000 and 400,000 unlawful border crossers. And about 120,000 of those were kids and moms and parents coming with their children. And so the portrayal of that situation as a crisis was really out of place, but yet that is the discourse that dictated the response. I will put it also in the context, frankly, it ties into some of the topics that we've just been discussing that Tom was raising. This was the summer when the administration was trying to push forward with a larger regularization or with a program that would allow more undocumented families to come out of the shadows and to have some security to be allowed to remain in the United States. And so the pressure was on to try to show that there was control at the border. And so that was absolutely a factor in the way the situation was addressed. But for those variety of reasons, the way the public press, really the way the press looked at it, the political considerations that were in play, the response was absolutely one of enforcement and of characterizing the incoming children and families as a national security situation. Law enforcement, but even more than that, sort of a national security situation. There was also a significant lack of preparedness. I think it's important to just put that on the table as well. That there simply weren't enough facilities for the children, unaccompanied children, to be held, even though the numbers, while much larger in 2014, had been increasing for some years. And the same in terms of processing for families who might be seeking asylum, because at that time, children who came with their parents were typically processed and released at the border in order to go to live in communities while they pursued their asylum claims. And there simply was a lack of foresight, I think, as a significant part of it, to prepare for processing of larger numbers of those families arriving at the border. So we ended up with kids at the Lackland Air Force Base, and then pretty quickly we ended up with the incarceration of mothers and children. It was really sort of the most extreme, sort of response that the government could have taken, and assumed that we could not handle the flows, even in the face of the lack of sort of foresight and preparedness ahead of time, but that we couldn't sort of ramp up resources in the immigration courts, in the Border Patrol, elsewhere, to process these children and families as refugees, as they really clearly were at the time. And so that's where we got to the sort of the beginning of the current situation. First, Artesia was opened, then Artesia was eventually closed, but we ended up with a family detention facility in Carnes. It's got space for about 800 mothers and children now. And then Dilley was open, has space for about 2,400 mothers and children. Both of those facilities are run by private prison corporations. And now, currently, this summer, there are several new proposals on the table to open new privately run family detention centers in Texas on a bid that was issued by the Department of Homeland Security, quite privately, secretly, some might say. Having now seen that call for proposals, it actually asks for the daily rate to be charged by the private facilities to be significantly lower than the rate that was being used to house families up until this point, which suggests that there will be even further incentives for the private corporations who run these facilities, if new facilities are adopted, to lower costs, to lower the standards of the detention facilities. The children, the situation of the unaccompanied children has settled down some, although there have been increased numbers again, as folks in the room can certainly tell us. But at least for the most part, with some expansion of the available shelters for kids, there's space not in an Air Force base for the most part for children in appropriately established and licensed facilities. There's still significant concerns about what happens to Mexican children as opposed to Central American children, because some of the Mexican children also have asylum claims, and many are just immediately turned back rather than being processed fully for their asylum claims. So that's sort of the current situation. Quite expansive family detention. New families are coming in every single day. Families of children are being deported every single day, at least several times a week. And then some are being released to go live with families after they pass screening interviews. Children are mostly being housed in shelters, but there are concerns about the processing of those children as well, unaccompanied children I'm talking about there. And I do want to just pause and make a point about the fact that while the processing of children, unaccompanied children, has its problems, there's no doubt about it. But the model is entirely different than the model for families. For the same kids, in fact, the kids who come with their parents are typically younger than the unaccompanied kids. But the unaccompanied kids are held in nonprofit shelters, and the whole purpose of the time that they're in the facility is to try to move them out and reunify them with family in the United States. Children who come with their parents are held in jail-like facilities where they first have to undergo a screening interview, a credible fear or a reasonable fear interview in the expedited removal process before they'll even be considered for release and even considered for the possibility of having their claim heard on the merits. And this is ironic because actually the situation for handling families is much easier. You can sort of understand that with children, as difficult as it can be, that you cannot just release them into the country without some guarantees that they're going to family. With children who come with their parents, they've got their custodians with them. And they can be released immediately at the border, as was the case when the administration abolished family detention back in 2009 up until 2014. So, current state of affairs, litigation and advocacy has made the length of detention much shorter for those families who are in detention, but it is still a significant problem. The families who are in detention have all experienced trauma. I've met with dozens, if not hundreds of them now. I believe the vast majority have very viable refugee protection claims. But even for those who may not, there is absolutely no doubt that they've been through deeply traumatic experiences that are significantly worsened by being in detention. So what will happen? Sorry, I spent a little. I just felt like I needed to give some clarity about how we got to where we are. So what will happen? What should happen? I think family detention will end. I really do. History is going to look very shamefully on this period where we detain mothers and small children in prisons. I was just at a panel yesterday on Japanese-American internment where the reflections of the horror of that period in retrospect weighed heavily, particularly because there have been individuals who were born in Japanese-American internment camps who've seen the family detention centers and recognize them as being very similar type facilities. I also think it will end because every entity in court to look at family detention has considered it to be unlawful. The U.S. Commission on Civil Rights, the Inter-American Commission on Human Rights, UNHCR has written amicus briefs on this. You have the court in RILR, in D.C., looking at the deterrent rationale for family detention and saying it was unlawful. You recently had a Ninth Circuit decision in the Flores case on the rights of children that said that family detention on its current model is unlawful as well because it violates the rights of the children to be released to parents as a priority, and if they're not going to be released, to be held in licensed child care facilities, which these are not, despite efforts by the state of Texas to license them. One actually is licensed temporarily. There's a trial on that in September. So, there's some level of ambiguity in that recent Ninth Circuit decision about exactly how far it goes, but it's clear in finding the current system unlawful and in finding that the old Flores settlement agreement that protects the rights of children must protect accompanying children with their parents as well. And I think it'll end because we have the skills in the United States to deal with these situations, with these refugee flows. We have excellent depth of experience in dealing with victims of trauma. The ironies, as Thomas was talking about in terms of training local police, and then the disparity of how we look at ICE, the same goes here. I mean, we've been working with law enforcement and dealing with trauma in the U.S. for quite some time now, and relatively effectively, and then we just throw that completely out the window when we're looking at Central American kids and who have that same trauma experience, often gender-based violence even, and other related experiences. We have experience with refugee resettlement, how to really handle refugee flows. And so I think that we have the skills to be able to do this. I think it'll happen because it has to happen. The women in these facilities with their children have so much hope that they are coming here because the rule of law is broken in their home countries. They come here with full expectation of the law. They're doing what parents do. They are pushing and pulling. They're doing whatever they need to do to get their kids out of harm's way. And I just don't think that we as a nation can tolerate a situation where that is penalized rather than protected. I have lots of recommendations about, sort of how we will end up in that place, but I won't bore you with those. Many of the recommendations were included in the ABA report on family detention that the Commission on Immigration published last summer, which we have some extra copies here if anybody is interested. But I think the central focus of those recommendations is, of course, to end family detention and to process unaccompanied minors in a much better manner, but also to really just recall that this is a refugee issue. This is not a national security issue, and it needs to be completely recast in that light so that the measures that are appropriate for dealing with a refugee situation can be applied, rather than those dealing with a national security situation. Another critical sort of piece of this and recommendation is that it's time to take access to counsel and provision of counsel seriously. There's litigation in the context of unaccompanied minors, JEFM, around trying to seek appointed counsel, at least for unaccompanied kids, and similar principles and rationales would argue vigorously for increased representation for families in these proceedings, in these very complex asylum proceedings as well. In the big picture, so I think we'll end family detention. I hope that there will be improvements in the processing of children. I do worry about the future in terms of detention and our handling of refugee crises. Unfortunately, I think significant damage has been done over the last period of time, the last 5 years, and it's not going to be easy to undo. Unfortunately, a lot of the sort of most negative aspects of what happened with family detention have actually now kind of reverberated and are now affecting immigration detention even more broadly. The priorities memo from November of 2014 was mentioned, which really prioritizes as enforcement all recent border arrivals, and so that includes refugees. So we're sort of treating possible refugee arrivals at the border as the highest priority for enforcement and detention across the board. And so that impacts not just kids and families, but refugee flows in general. And I really genuinely believe that the Central American refugee crisis is a significant human rights and immigration crisis, in our time. And I'm worried about the damage that has been done in the way that we've handled it and how that will continue to reverberate for this crisis and for the next refugee crisis. Thank you.
All right, next we'll turn to Ms. Sheehy.
Good afternoon. I appreciate the opportunity to speak with you today about the challenges retain foreign national employees. I have an employment-based practice, so that means I work with U.S. companies to file petitions that allow their foreign worker population to work and reside in the United States. We typically file a non-immigrant visa application first before transitioning the foreign worker to permanent residency status by getting them a green card. I thought the best way for me to illustrate the challenges our clients face with our outdated immigration system is for me to share with you a few of the questions that I'm asked on a daily basis. My hope is running through these Q&As will make clear that the employment-based immigration system does not meet the needs of U.S. companies and businesses or the foreign national talent that these companies seek to hire and retain. Along the way, I'll try to provide some common sense suggestions and solutions that will help American businesses. And I hope I'll close with some predictions on what we might expect from the next administration. So question one, this is the question that I've been getting basically every day since April 1st, is that the H-1B petition we filed in April for a key member of our team was not selected in the H-1B lottery. What options do we have to bring this foreign worker to work for our company in the United States? My answer is, although we can explore whether this foreign national and the job that you offer qualifies for another non-immigrant visa category, it's very likely that you're going to have to wait until April of 2017 in order to file another H-1B petition, which will again be subject to the H-1B lottery. So the problem that's raised in this Q&A is all about the H-1B visa category, which happens to be the most common non-immigrant classification used to bring foreign workers to work in a professional capacity. The annual allotment is approximately 65,000 members for all U.S. companies that want to hire a foreign worker in a job that requires a bachelor's degree. During the last several years, the United States economy has been good, and the H-1B visa category has been increasingly oversubscribed, meaning USCIS has received substantially more than 65,000 applications or petitions each year. And when this happens, USCIS conducts a random lottery to select as many cases as, when adjudicated, is expected to fill the approximately 65,000 H-1B slots that are available. This year, USCIS received over 236,000 H-1B petitions from U.S. companies during the first week of April. Only 27% of the petitions received were selected in the lottery. Last year, the odds were a little better. You had a 36% chance of being selected in the lottery. These statistics show that U.S. companies would like to have many more workers in H-1B classification than are currently available. So what should happen? We think in our office that there's no question there has to be an increase in the number of H-1B visas, particularly when the U.S. economy is strong. And of course, this solution might be a little bit controversial, but increasing the number of H-1B visa numbers so that it's more commensurate with the need of U.S. businesses is absolutely what must happen. And of course, there's a lot of disagreement as to the impact that foreign workers have on the U.S. economy. But a study done by the Economic Policy Institute was particularly nuanced because it highlighted that the impact of immigration also depends on how the economy is doing. When the economy is strong, the impact of immigration could further strengthen the economy. And as it stands now, the United States government limits the number of work visas available without any consideration of the strength of the economy, which in turn means that the economy is not really positioned to fully benefit from immigration when conditions are good. Plus, the statistics are just so startling in very clearly showing that the current allotment falls far short of what U.S. businesses need. Question 2. My H-1B petition was filed with USCIS more than 4 months ago. When can I get an answer about my case? My answer. USCIS is taking more than 7 or 8 months to adjudicate H-1B petitions, and there are no accurate processing time reports that would allow us to give you a better prediction as to when you can expect an answer. In fact, the last processing time report for the California Service Center, where your case was filed, was published in May. You may want to consider paying the premium processing fee of $1,225 to expedite your case. The problem raised in this Q&A is that currently, and for quite some time now, many of the most common immigration applications are facing extremely long processing delays at USCIS. The delays are so extensive that the American Immigration Lawyers Association sent a letter to USCIS in March on this topic. The impact of processing delays is very, very significant for the foreign worker. For example, the foreign worker probably can't renew his or her driver's license until the application has been approved. There are also restrictions on international travel while the application is pending. And although some applications are eligible for premium processing, not all of the applications are eligible for this faster service. In terms of a solution, as requested by AILA in the letter to USCIS, we would like to see, at a minimum, more accurate published data on processing times and greater transparency as to what's being done to address the processing delays, given the extremely high filing fees that we're paying. Question 3. I need to travel to India for a week, but I don't have a valid H-1B visa in my passport. My visa expired a couple of months ago. I do have a valid H-1B petition that was just approved. Can I travel to India? My answer. You can't go to India unless you can take 3 months off from work, because it's taking more than 3 months to get a new H-1B visa from the U.S. consular post in India. I think in June of this year, the Department of State announced that the consular posts in India are experiencing extraordinary wait times of 2 to 3 months in order to get a non-immigrant visa. And the wait times are so extreme that the Department of State was seeking approval from the government of India to add consular positions. So 2 months later, I checked the processing times for non-immigrant visas at the U.S. consular post in Chennai, and as of yesterday, August 4th, it's taking 101 days to get a non-immigrant visa at the U.S. consular post in Chennai. That obviously puts a lot of people in a very difficult situation if they need to travel internationally for a short period of time. In terms of a solution, a common sense solution to this problem is to expand the concept of automatic visa revalidation. Right now, non-immigrants who travel outside the United States for 30 days or less to a contiguous territory, such as Canada or Mexico, can return to the United States without a valid visa. In my office, we think DHS should consider expanding this to include non-immigrants who travel anywhere for 30 days or less when employment hasn't changed. This would significantly reduce the delays and burdens of obtaining a new visa for people who previously had one. And question 4, the final question. I'm from India. Do I really need to wait 12 years before I'm eligible to file the adjustment of status application to get my green card? Answer. Yes, you need to wait 12 years. The August visa bulletin is showing that the immigrant visa retrogression for Indian nationals is almost 12 years. So just like there are numerical limitations for the number of H-1Bs that are available each year, there are also numerical limitations on the number of green cards approved each year. Why is there such a significant delay for Indian nationals? Because in addition to limiting the total number of green cards available each year, the United States also imposes per country numerical limitations. And that means people from countries with larger populations immigrating to the United States will face significantly longer wait times to get their green cards as compared with people from countries with smaller numbers immigrating to the United States. India and China have the largest populations immigrating to the United States. On top of that, the spouse and children of these applicants are also counted against the numerical ceilings for each country. So in terms of a solution, most of us who practice employment-based immigration believe that the immigrant visa system needs to be substantially revised to eliminate per country limits such that the applicants can file their adjustment applications much more quickly than waiting 12 years. But a non-controversial solution might be to eliminate the counting of the derivative family members against the per country cap. This idea has been written and blogged about by immigration attorneys and professors who have argued that if the immigration laws don't require family members be counted, and by eliminating family members from the count, the immigrant backlogs can be significantly reduced. So in terms of what we can expect from a new administration, I think candidate Trump, I just fear that it will all be bad. No good can come of it. And candidate Clinton has said that she's in favor of comprehensive immigration reform, including at her speech at the DNC. Her view seems to be that she's going to consider immigration reform as a whole versus reforming work visas apart from other areas of immigration. So let's hope that candidate Clinton leads a new administration because we're looking forward to comprehensive immigration reform.
All right, so with that, I know a bunch of people here are not shy, so do we have any questions for the panel? Okay, fine. Make it not shy, that's something.
Never shy. Not shy. Professor, let me put a question that when you talk about the future raises all the points of sensitivity you covered as to why we need reform. But from a policy point of view, what would you say is the number of people that have to amass in El Paso at the border at one time that would let you say that number can't be admitted, certainly now, and we would turn them away? Is there such a number?
Tough question. I actually don't think that scenario. I think that's the fear, right? That's the even talking to people in the administration about what happened in the summer of 2014. That's sort of exactly what they were envisioning in their better moments. I think there were, as I say, other things going on as well. But you know, is this really? They said the numbers just seem to keep going up. You know, how do I know they're not going to just keep going up? I think that's. I don't think that's likely to happen. You know, experience in immigration and refugee flows historically around the world, there are others in the room who know even more about this, show that, you know, the incentives to leave have to be extremely great. Only about 2% of the world's population actually migrates. Of course, there are bigger sending countries and there are bigger receiving countries, and we're certainly a large receiving country. And this is a real crisis in Central America. But the reality is that those who possibly can stay are likely to stay. And the numbers just, I think, are never going to be at that level that we would be unable to process them, especially when you look at the numbers in 2000 of 1.5 million unlawful border crossers as opposed to these 400,000. Remember that in the countries surrounding Syria, there are 3 million displaced Syrians just in that region around Syria. We're talking about 120,000 moms and kids. And so I just think when you look at those numbers, it's not even sort of worth raising that scary specter. If it was significantly more, I still think we could process that. It's not that hard to process and allow the adjudication process to go forward. That's my opinion.
I'm going to give my opinion, which is it's the number that requires this, that eventually gets this country to treat a refugee issue as an international issue and not solely a domestic issue. It's the number that gets us to the point where we start talking with Canada and Mexico about how to address a refugee crisis. And in those conversations, of course, those countries will appropriately point out our country's responsibility, higher than any other country, for the conditions in the Central American countries that then require these refugees to flee. So it's whatever number is going to have us start facing up to this issue, like the rest of the international community in Europe and elsewhere has had to face up to the issue, and face up to our own responsibility, including the impacts of our immigration and deportation policies on those countries that we have been following decade after decade, and then, lo and behold, have effects on the immigration flow to this country.
So we have a question here, and then to Doreen. So
Well,
first,
just to follow up on Bob's question. So, Professor, you mentioned, for example, the numbers of Syrian refugees and the impact in other countries. So do you think either with respect to those that have some real means of affecting the policy, as well to the general public, is it helpful to add that calculus to the discussion about what we should do with Central American refugees?
As a comparative issue
Yes.
to sort of think about? Absolutely, and I'll use that to make a plug for another panel that's going to be taking place tomorrow morning that's going to be looking at sort of the refugee crisis and handling in Europe as well as in the U.S. I think, there are probably as many lessons learned on both sides as there are poor lessons learned, and so we need to be cautious about what we're comparing and contrasting, recognizing the differences in the situations, recognizing where responses have not been appropriate, both here and in Europe and in the countries surrounding Syria, thinking really about sort of a better global structure for dealing with refugee crises, with the U.S. actually taking a meaningful leadership role, which I think, unfortunately, as I have said, on the Central American refugee crisis, it has been a step backwards rather than a step forward in terms of reaching global agreement about how we handle these situations. But absolutely, there's a lot to be looked at in terms of comparison.
question from Doreen Johnson.
I wanted to ask a little different question about employment or immigration. Congress loves to talk about the exalted guest worker program. If everybody used that, since I do employment-based, I do some what they would call the guest worker program, and it is cumbersome and awful. And this year they made mistakes in it and put a couple of my small business clients out of business because they interpreted something wrong, and then one on appeal, but it's 8 months later. It doesn't really help a small businessman very much. I'm on the Immigration Commission. One of the trips we took on one of the borders, excuse me, one of the members of the Customs and Border Patrol said, who was from Mexico, his heritage was Mexican and Iranian, and he said he thought that one of the issues we had in the United States was when we started closing the borders and stopped letting people go easily back and forth, because a lot of folks would come and work and go home. Is there anything that you see, anybody on the panel, prospectively, or anything that might do to actually, I suppose, retrogress the program back to when people could much more easily cross the border and go home to work? Because I get sick of Congress talking about how, oh, the guest worker program is perfect. Well, it's a terrible program in how cumbersome it is.
Either one of you want to take?
I mean, I'll just comment that I think there's absolutely a lot to that idea that much of what's happening in terms of our undocumented population in general is based on the fact that the labor is actually absolutely invited here, and then it's harder for there to be market responses based on labor needs when it's so much more difficult to go back and forth across the border. I'll note that, you know, I do think the refugee situation is a little different.
Yeah.
You know, there, even in the refugee context, of course, folks talk about the desirability of making it possible for people to return home. And of course, that's always something that you would want to have in the mix, is that mobility back and forth when conditions become appropriate. I think in practice around the world, it has been less often that has been a feasible response because once protection is offered, sure it is, you know, people establish roots, and it's harder to have that cyclical.
And the refugee point, I absolutely agree with you. If you're fleeing violence, and I mean, that's a whole different thing.
Right.
But if you're looking at economic immigrants, if you will, it just seems to me that we ought to look at that. We don't talk about it very much. Congress just likes to pretend that's a solution.
All right, there's a question back here and then here. So, thanks, sir.
Two quick comments and a question for Denise. Just, I agree with Denise's and Tom's response to Bob. Well, I will say, Tom, I don't know of any country that has ever accepted refugees because they felt responsible for the flow. So I'm not sure that's...
But in concept, at least.
I'm not sure that's a winning argument. The second point is just for Tom and Jennifer. Even if Hillary Clinton wins, I think you're blocked in the House of Representatives. You have such a right-wing House and no chance that's going to change. It's really hard to see comprehensive immigration reform happening unless the Republican Party really divides in two and you can peel enough Republicans off to go to the Democrats. But that just seems really unlikely. I think the real answer is the fifth justice that'll get the case decided the right way if you're going to really try to move people forward. My question of those to Denise. So what's there, because of BIA decisions and the definition in the convention, do you think there are other routes to protecting Central Americans besides this? I know judges are granting these cases in kind of weird and interesting ways and keeping them, the government isn't appealing them, so you're getting a lot of grants in ways you wouldn't predict. But what else should we be thinking about? TPS, parole, humanitarian? What would you recommend?
Yeah, no, thanks for that question, actually. With more time, I think that's a really important area to expound upon. I think realistically we've got to get away from the individualized case adjudication full-on in immigration court in each and every one of these cases, in part because there's significant pressure on the immigration courts there's significant resource pressure, which is really stymieing the whole system. I think there's also pressure because of the way the whole situation was cast in 2014 to deny, frankly, to keep the parameters of asylum law limited in ways that I think, asylum law is subject to interpretation like everything else, and I think you could interpret it this way or another way more broadly. I think the broader interpretation is correct, but regardless, there's an interpretation problem there. And so you are seeing some wins, but you're actually seeing a lot of losses too because of that. Then there's just the lack of ability to obtain representation for these numbers. I mean, if you're really talking about just the numbers from 2014, that's 120,000 cases somebody's got to represent. And while the pro bono response has been fantastic, it just can never meet that need if these are going forward full force litigation in immigration court. TPS is one possible response. Of course, it's time limited, so it will only help us up until now. And then it doesn't look as though, per Bob's concern, the flow is completely going to stop tomorrow. There may be ebbs and flows, but so that doesn't really resolve the situation either. I'd like to see us go to a parole situation for sure, getting people into the country to await some outcome on their cases in terms of release from detention. In terms of humanitarian parole as sort of the status they have here, that could certainly be one option. Of course, there's experience with that, with Indo-Chinese, with Vietnamese parolees, when those numbers were very large. I think what I'd most like to see, if I had my complete dibs, is a presumption of eligibility for refugee protection or asylum, because that's a much more secure, long-term, stable status for folks coming from Central America, and having that be processed through the affirmative asylum process, so not in immigration court.
I'm a business immigration manager as well, and I kind of wanted to raise a point that you made. Jennifer, you're saying that you wanted to push forward like comprehensive immigration reform. We saw it fail in 2007. It didn't work in 2013. Some of the issues that we're seeing with the H-1B are the result of certain outsourcing companies treating individuals as commodities and filing tens of thousands of visas on behalf of one company, sucking up all of the numbers. I think realistically, as advocates, we should be looking at bifurcating an approach and sort of separating out some of the needs of the business community and those that are looking for humanitarian relief and putting in a parole in place or whatever model. And personally, I think it's easier to close, you talk about your 4 points and 4 questions that we all get regularly. I think it's easier to close those loops, even from a regulatory perspective, than to do it through a comprehensive immigration reform. There's certain bills that we're seeing coming up where they're talking about allocating some of the numbers that currently exist for employers of certain sizes to give everybody a little bit more of a fair shake at the visa numbers available. And I know that there's this thought of like trying to rally all constituents to push through a comprehensive reform, but I'd like to get everybody's thoughts kind of as to why aren't we thinking about shifting our perspective and trying to take a multifaceted approach to reform?
Let me just start by saying that I'm not really saying that I'm advocating for comprehensive immigration reform. Clinton has said instead that she's not going to bifurcate the work visa issues from comprehensive immigration reform. And that also wants some criticism from the business community in particular. I agree with you completely. I personally think comprehensive immigration reform is dead. The likelihood of it happening are just non-existent as far as I'm concerned. And
if Trump keeps putting his foot in his mouth, maybe we'll get enough people to current there. But yeah.
Yeah, and in terms of the H-1B visa problems, there's also a proposal or a lawsuit that recommends the same type of system for the H-1B oversubscription as there is for the immigrant visa oversubscription. So my practice is primarily with labor certifications. And given my experience with the ID backlog for Indian and Chinese nationals, I don't really know. I mean, from my perspective, it's not a particularly desirable solution. So you wait. I mean, it's not real world. You wait 12 years for your foreign worker to get a temporary H-1B visa. How does that work?
Yeah, I would hate to see a per country limitation on non-immigrant visas.
Not really a per country limitation, but just in terms of the oversubscription. So you have your place in line, and then so instead of a lottery system, this year they got 200, some odd thousand applications. They'll take the first 65,000. I'm not sure. Maybe it'll be through a lottery system, and everybody else, the next group of 65,000 people will get it the following year. But it's still not. It's not viable for businesses. That's just not how things work.
Question from Meredith and then back to Bob.
Denise, I'd like to hear you address the raids and how you feel about the post-order enforcement efforts by the administration.
Post-order.
I mean, the raids and the deportation of...
Well, after, right. Gotcha, I'm sorry, yeah. So we didn't touch on this for those who haven't caught up on this particular piece of it. Starting in January of this year, there have been raids at homes, very what you envision when you hear raids. Guns drawn, uniforms, knocking on doors at 6 a.m., not in the middle of the night usually. I've spoken with a number of the moms who were subjected to these. And who's being raided are principally two categories. One's their family detention folks, so moms and kids who were either processed at the border and let in, or who were in detention for a while and were released, and then either missed their court date because they didn't have information about it, had representation in many cases where the lawyer refused to even file an asylum application for them because for one reason or another didn't get paid well enough or whatever it is. And so they had orders of deportation based on that. So that's one category, the moms and kids. Another category, and I actually think this one's even worse in many ways, these kids who came in as unaccompanied kids. So they went through that slightly softer process and were released pretty promptly to live with family. And now they've turned 18 and they're adults. And they're being prioritized as an enforcement target. Some with orders of removal and some who don't. Some who are still in the immigration process. But now they're adults, and so theoretically they're undergoing an immigration process where they could be detained in regular adult detention facilities. And so some of those kids are being picked up as well. So that's deeply problematic, of course. And I think it does, it points out once again the extent to which this has all been cast as a question of law breaking and sort of law enforcement and the need to make sure they comply with the law when in fact the legal obligations of the United States to treat these cases as proper refugee cases, I would say, outweighs the law breaking. That it really isn't law breaking. That's how you seek asylum. For those who aren't familiar with the system, is you come to the United States and you seek asylum. There's a very, very small program allowing certain kids in Central America to obtain refugee status there and come. But it's a very, very small program, only about 100. I don't have the current number, maybe it's 250 now. Folks have come that way. So the rates are deeply problematic. It plays into the, kind of the narrative that the administration has continued to portray, which is that, well, if we just release these families, they just disappear. See, there's a bunch of these families that we picked up in the raids do have these final deportation orders. Some of them didn't appear for their hearings and so forth. Frankly, some of them got orders of removal. Frankly, I think those statistics show what's wrong with the government's approach to this whole situation. The in absentia orders, I know from speaking to many of these women, are largely because the government failed to give proper and complete information about what the hearings were, when they were taking place, and the like. And so that's a real failing. It shows that if the government were to provide the right kind of information at the right time, you could dramatically change, what's happening in the process, and people could be trusted to go to their homes and then show up for hearings. It also, again, I think shows this reality that there's been a lot of pressure to deny these cases. From the very beginning, starting in 2014, high-level officials came out and said, these are not asylum claims, we will quickly detain and deport these children and these families. And so when that's the reality of how the asylum claim is being adjudicated in court, it's frankly not that surprising that some of them do have final orders of deportation, that their asylum claims were denied or perhaps never even filed because the attorney knew that that judge is taking that claim very seriously, that these are not asylum cases, and is going to deny no matter what the claim actually is. So I think those are demonstrations of the need to take a completely different approach, but they're used by the government to justify detention.
Question here and then here.
I just want to take on Professor Gilmore. Your answer to my question ended up with let them in and create a presumption of their right to be here, and then the truth is the government has no way to cross-examine these people. They come without documents. Half of them are too young to remember anything. The government will lose in that presumption more times than not. So the government has an answer for you, and they've started it, which is something I find even more offensive, which is to say nobody gets in. Go consular process in your home country. And if you got to flee from there, go wherever you want to go, but don't traverse Mexico and come here. Stay in Mexico or wherever else you want to go. And we'll help set up safe centers elsewhere, but not here, because our people do not want to grant, simply by the act of crossing and making the claim, everything that constitutes benefits, education, and the rest. Because we have local people who have been seriously displaced in some communities. All right. So the answer to my government tends to give every time they look at alternatives is consular process. It's a great theory. I watched consular processing in Haiti, where people lined up early in the morning. And before lunchtime, the line ended, and people on that line were taken off by tauntauns, and they were either beaten or killed or forced to turn over money or get family to turn over money. So if there are gangs and others that are really driving people out, they will learn that consular processing, particularly since the in-country bridge man, who's not the consular officer, leaks information, people will know. There's a risk with consular processing. But I'm still not happy with your answer. Because if I've got, and I know Tom was correct, that somebody would negotiate. But the Swiss said this in the 1870s in rejecting the treaty. If they're at my border and there's X of them, as a matter of law, I want the right to say no. And so every time I debate, because I prefer your position in making my own assessment, I get stuck in response to the question, you're saying either you're for open borders or you got to tell me some number, at least that gives you goosebumps. Is there a number, Professor, that gives you goosebumps?
I feel like we could, spend hours and hours discussing these ones, and I know that you're, in part playing devil's advocate, and it is helpful to the conversation for sure. I have no doubt. I think that's the whole problem, though, is why are we only intent on thinking of situations that we can't handle when we can handle this situation properly?
We're in agreement. But
So let's do it.
The debate,
And then we'll worry. And then
Okay, Bob, we gotta get to some other questions here.
the debate on TV is one sentence, not the debate.
All right, we have to get some.
Well, I don't have a question. I'm a former immigration judge, retired, and I want to speak up for the independence of the immigration judges. They do not follow any line of anybody in the government saying these people all need to be denied. That does not influence an immigration judge's decision. Even the president said that. But the immigration judges consider the cases on an independent basis. And I think respecting and recognizing the independence of the immigration judges is very important.
Good.
Thank you very much. Question over here.
Yes. So I really appreciate the remarks. Thank you to everyone on the panel. My question, I think, is directed both to Tom and Mr. Gilman. Is this question that, yes, I think it's fair to say on the implementation side that there have been some really large stumbles, and also on the we could have done something better in 2009 when the numbers started increasing, and we didn't, and then in 2014 it became a very reactive response. And my question is sort of a challenge to say, how do, knowing that immigration is always going to be so politically charged and emotionally charged as an arena, what are the ways that you would recommend from sort of outside of government? Would you recommend that government may it be the next administration, or may it be the career civil servants who are, going to be there for the longer terms? As Tom mentioned, even with respect to this difficult with the implementation of local police departments, how would you recommend sort of changing that culture of having more foresight and having more of an environment where you're talking about immigration enforcement, more of an environment of looking at the future rather than a culture that, I think very much is a very reactive culture right now. But I'm curious to hear it. It's easier to say it's reactive than to say, here's how we change that and how we shift that.
I don't have an easy answer, but I think the problem goes back so long in how we've dealt with immigration issues even before the current set of controversies, that there are common wisdoms, there are accepted frames of reference that really put us at that place when it comes to so much of this. So it has to be incremental. And when it comes to enforcement, I think, frankly, we have to do both. Ensuring that we're doing the work to change the culture inside the enforcement agencies, and we are allowing the kinds of discretionary initiatives that the court regrettably left in place because of the deadline to move forward. My hope is that as the country becomes more immigrant aware and immigrant connected, because that is happening. We're reaching levels of immigration, which then in turn means people feel a closer connection to immigrants and immigration. And before that, maybe we can start to change some of those long-standing frames of reference that have us viewing immigration as an entirely domestic issue without regard to consequences of our deportation policies, for example, long-term consequences of deportation policies, for example, not just on the countries that we're deporting back to, but on this country, that has us thinking more long-term in terms of all of these issues, instead of short-term, and at least as important, that we end up with a voting community that rejects those who exploit the issue in ways that even they know are not productive as policy matters. They're simply productive in their short-term political calculation rather than long-term policy calculation. It sounds like a pipe dream because it is, but maybe the chance comes when population changes sufficiently.
I agree with all that, and I guess the only other thing I would say, and there has been some significant work done on this in the refugee context around the world, and in the U.S. somewhat, is really trying to make the rational and emotional argument for the benefits of immigration, whether those are refugees or others, economic benefits in terms of increased tax base and larger economy and workforce where needed, as well as the sort of more intangible benefits of entrepreneurship, people who are highly motivated and who bring a lot, and the cultural benefits of having that here. But it's also hard.
Okay, so two last questions, I think.
Again, not a question, just a comment. The current political environment seems suddenly very anti-trade. And when you think about trade as another side of immigration, it could be that if we had more trade, fewer people would want to migrate because they'd have the opportunity to work in their home countries. Another little thought that my husband, my late husband, who is an economist with the World Bank who worked on urban issues, has espoused is that the migration we're receiving currently from Central America is kind of the tail end of the southern to northern migration that our country has experienced for many decades of people from rural areas, primarily southern rural areas, used to be from within the U.S., migrating north to the cities. And most of the migration, I believe, that's coming from Central America is from rural areas. I don't think people are coming from San Salvador. I think they're coming from San Miguel and other places that are not urban. And so he sees it just as a natural progression of rural to urban migration.
So Karen, I think we have a last question. Go ahead.
Oh, okay. Well, I don't think it's important enough to be the last one, but I wanted to follow up on an idea or suggestion that Denise had about shifting the forum for the adjudication of the family-based claims to the affirmative process. about sort of the rationale and how you would conceive of that. I've seen a lot of the family detention cases where the child is found to have the credible fear and the parent is not, but they both get put in proceedings. And they're calling it like putting the mother in proceedings as a courtesy. What I wanted to ask about your recommendation is, do you see that as a structural change or as a way of getting around the problem where the child goes forward at the asylum office and then the mother's claim later gets adjudicated in court, or the mother is getting PD because the claim is perceived as weaker but the child is granted? Or how structurally are you getting to that recommendation as opposed to adults more broadly getting, you know, ER cases getting shifted to the affirmative?
Right. I mean, I guess as whether I think in general it would be a good idea to try to figure out a way to get more of the refugee, the asylum process into the affirmative side of things rather than the court. In the ideal world, my answer would be, I'm sure you're not surprised, that yes, that would be great. I think families and kids are a great place to start, and there are lots of reasons for it that are based on resources as well as the underlying kind of refugee obligations and concerns. So that's the main reason why I would carve out families and kids. But you're right to point out that there's already sort of a model for this in the way that we handle unaccompanied minors cases, and so it would really just be sort of extending that in some ways with some additional tweaks in my ideal world of the presumption, but extending that idea that after apprehension at the border that you still are able to go through the affirmative process rather than going through the adversarial immigration court process.
Because it strikes me that if the child is going to go there, it's more resource sensible and having someone understand the claims together rather than having them go in two different directions. But
absolutely,
that probably requires a statutory change, don't you think?
We looked at some regulatory possibilities, or even I think potentially.
We're at our time. Please welcome, please join me in thanking our panel.